the PDF.
Good evening, everyone. I welcome you all to today's webinar organized by Center for International Alternative Dispute Resolution (CIADR), which is the first and only online dispute resolution center in Bangladesh, providing the most natural, reliable, and cost-efficient CIADR is now renowned for its fast-rating dispute resolution tactics and having the most experienced independent arbitrators and mediators in South Asia. Recently, it has spread its young wing named YCIADR, means Young Group of CIADR, and acknowledged more than 600 plus registered students members of YCIADR throughout the whole country. ADR News, ODR TV, Research Center for Conflict Resolution, ODR Institute and Membership and Communication Department are the recently established six highly functional sectors of CIADR. These sectors are headed by the most enthusiastic and remarkable law students and young lawyers of Bangladesh who signal their persistent passion to spearhead a new era of ODR development and expansion, both for CIADR and global ODR ecosystem. Along with the large growing network all over the country itself, CIADR is now targeting to expand in network and open chapters in other countries like India, Nepal, Pakistan, as well as African countries too. CIADR aspires to be the provider of uninterrupted premium institutional aid as a tangible and independent venue to conduct the domestic and international ADR and ODR proceedings. The ODR Webinar Series is making a path to create an actionable community and ensure solutions to combat the future economic crisis in the global community. On behalf of Center for International Alternative Dispute Resolution, I will be hosting today's webinar. I am Mahera Binte Rofi, Associate Counsel of CIADR and working as the Director of ODR TV. I am also working as a pro bono mediator for CIADR. I have pursued my LLB and LLM from the University of Dhaka and now currently working as a research associate in Lex Counsel. The topic of today's webinar is Form and Substance of an Enforceable Arbitral Award, Avoiding the Pitfalls and Arbitrators View. I will take a few moments to discuss briefly about today's topic and introduce our today's keynote speaker. The issuance of an arbitral award by the arbitrator resolves the issues and ends the legal battle between the disputes of the parties. Or does it? In some cases, the issuance could be the beginning of another long series of arguments in a setting aside application at the court of the seat of arbitration or in resisting enforcement at the enforcement jurisdiction. A majority of arbitral awards survive attempts at setting aside or resisting enforcement. Quite a few do not. In this webinar, our honorable speaker, Ms. Earl Rivera Dolera, will canvass the fundamental principles and requirements of an arbitral award of enforceable in any New Year Convention jurisdiction. We will also survey the legal basis referred to by courts from certain jurisdictions, why they have set aside arbitral awards or refused their enforcement, and provide a commentary on whether such reasons are following international best practices and standard or not. Either way, it will be helpful for any arbitrator to keep abreast with case authorities in jurisdictions pertinent to these cases to avoid issuing an unenforceable award. Ms. Earl Rivera Dolera is a tri-qualified lawyer in England and Wales, New York, and Philippines. Based in Singapore, she is an arbitrator and an academic and has acted as a counsel, tribunal secretary to prominent senior international arbitrators and justice law clerk in her legal career. Earl has been appointed as arbitrator in cases with seats of arbitration in India, Singapore, Indonesia, Philippines, and Hong Kong. She is listed as the panel arbitrator at a number of arbitration centers in Korea, Japan, China, Hong Kong, Thailand, and Singapore. As Tribunal Secretary, Earl has assisted tribunal arbitral awards in numerous jurisdictions in arbitral proceedings seated in Nigeria, London, Singapore, Hong Kong, Vietnam, India, Australia, Malaysia, Indonesia, Republic of Korea, Thailand, Sri Lanka, Germany, France, and United States, with the total claim of US $7.2 billion. Under CIA, KLRC, SCMA, AMTSC, HKIAC, BIAC, BANI, CIETSC, ICDR, ICSID, and ad hoc arbitration. She has also written extensively in the area of international arbitration, including having co-authorized the volume in the Halsbury series, Halsbury's Law of Singapore Arbitration 2017 and 2020 reissues. Educated in the US, Singapore, Shanghai, China, and Philippines, she is a fellow at the Chartered Institute of Arbitrators UK, Singapore Institute of Arbitrators, and the Asian Institute of Alternative Dispute Resolution in Stanford. She was a Salzburg-Cutler Fellow for International Law and Jean Monnet Research Fellow for European Union Law and Investor-State Arbitration. She is active in promoting international arbitration and acts as a speaker, lecturer, or training events or workshops in Singapore, Japan, Cambodia, Thailand, Taiwan, Philippines, California, USA. And now, without taking much time, I would like to give the floor to our speaker to start the session.
Thank you very much, Mahira. First of all, I'd like to apologize for the delay. As the technical difficulties of conducting an event that crosses borders. So I prepared a presentation for everyone today. I think it's more interesting than a PowerPoint slide because it has some animation going on. But due to some technicalities, it's the PDF version that we will be showing today, and I hope it will still be understandable for everyone. So without further delaying our webinar, let's go deep dive into the fundamentals of award writing and possible pitfalls in what to avoid in writing awards as arbitrators. In the hope that many of us will be arbitrators in the future, or will get a lot of arbitrator appointments in the future. So I divided my talk into four. We'll talk about the rationale behind these fundamentals, and then we'll talk about the form of these fundamental elements that should be put into the award. And we'll talk about the substance, the reasoning behind award writing. And lastly, we'll talk about the pitfalls, what to avoid in award writing, so that our awards as arbitrators will not be held unenforceable or will not be set aside in the seat of arbitration. Next slide, please. We'll go to the rationale. Okay, the rationale. I would point out or highlight 2 points. As arbitrators, we want an arbitral award that is valid and enforceable. That's very important, especially for the winning party. A valid and enforceable award that could be enforced in any of the countries that has ratified the New York Convention. And second, a valid and enforceable award is the badge of credibility for arbitrators. It's a badge of honor for arbitrators. When counsel or parties to an arbitration come up with a list of arbitrators to appoint, I could speculate or surmise that one of the factors that they would need to see is that this arbitrator has not that was set aside or an award that was held unenforceable. So this is a badge of credibility. So what should we look out for so that our award will not be held unenforceable or set aside? Let's take a look at the New York Convention first. Next slide, please. That would be there. Article 5. Okay. Um, it's quite a lengthy provision of Article 5 of the New York Convention, but this is the provision that sets out the grounds or the basis for refusing to enforce an arbitral award. I do not mean to let you read such a lengthy provision, but just to highlight some key points on these provisions, one of which is the first subparagraph says incapacity. So if your award awards or makes someone who is incapacitated, let's say a minor, um, an imbecile, make someone liable in that award, then that award might be resisted, might resist enforcement at the enforcement jurisdiction because it was made against a party that has no capacity to enter into that contract. And the subparagraph 2, there was no proper notice of appointment of arbitrators, or the or one party was not afforded an opportunity to present his case. This usually happens if one party, usually the respondent, does not participate at all in the arbitration proceedings. And then when the arbitration continued and an arbitral award was issued in favor of the claimant goes to court and have the arbitration award, the arbitral award enforced. And then suddenly the respondent appears that we were not afforded an opportunity to be heard in the case. That could be a ground. We'll see later how we could go against that basis. Subparagraph 3, when the arbitration deals with a difference or issues that were not submitted for the jurisdiction of the arbitrators. I'm just pointing out the keywords here because I'm not asking you to read this lengthy provision. So for example, the claimant and the respondent only ask the arbitrator to decide whether the respondent is liable for demurrage in a shipping dispute. And then the arbitrator decided not just demurrage, but also discharges, bad weather condition liability, and all these other liabilities that falls outside the merge. Those that fall outside the merge could be resisted enforcement. Subparagraph 4 also says if the composition of the arbitrators of the tribunal is not within the agreement of the parties. I could give you an example. For example, the arbitrators in the arbitration agreement, the arbitrators should have at least 10 years experience in the shipping industry. And then all of the arbitrators that were appointed didn't have that 10 years experience in the shipping industry. That could be a valid ground as well for resisting enforcement. And then on the second, on Article 5(2), we have the public policy exceptions, and the subject matter is not capable of arbitration. An example for this would be criminal law issues, divorce, matrimonial family issues, which should not be settled via arbitration. Next slide, please. We go to this one, Article 34, subparagraph 2, under the UNCITRAL model law. I've set out all these provisions for your reading perhaps later or in the next few days. But as you might be able to see, these are similar grounds under the New York Convention. But UNCITRAL model law, Article 34, subparagraph 2, sets out the grounds for setting aside an arbitral award. And usually the setting aside application is filed in the seat of arbitration. For example, if the seat of arbitration is in Singapore, and then let's say I'm the respondent who lost in that arbitration, I could bring the arbitral award to the courts in Singapore and have it set aside. So the term is setting aside or set aside under these following grounds. So these are the only grounds, plus under the laws of Singapore as well. These are the grounds that could be made my basis in my application to set aside the award. So just to highlight, if you're the arbitrator in a case, always note the New York Convention grounds for resisting enforcement of the arbitral award and the UNCITRAL model law grounds for setting aside an arbitral award. Once you have mastery of these grounds, you as the arbitrator would know what to avoid in writing your arbitral award. So these are the major points that I would wish to highlight. Next slide, please. We can now go to the fundamental elements or the form. We'll now go to the circle number 2, form. Next slide, please. Form of the award. I've divided the form of the award into 2, the procedural steps and the dispute resolution steps. Let's go first to the procedural steps that should be put into the arbitral award. First, a cover page. This is usually the first page. It's not mandatory, but it would be very helpful, for the work of the administering arbitral institution. For example, if CIADR is the administering arbitral institution, if I submit my award to them, they could immediately see from the cover page, that case title, the case number, the type of the award, and the names of the parties. What are the types of the award, if I might ask? There's the final award that resolves all the issues in the case. There's an interim award or a partial award. There's an order for injunction or orders for interim relief. There are also awards or decisions on jurisdictional challenges. Then that should be put into the cover page already. It's also usual practice to already put the names of the arbitrators on the cover page. But very important, put the names of the parties right on there, on the cover page. And I wish to highlight, always set out the correct name of the parties. Okay, I'll give you an example. One respondent was a state, and there are different complete, full, formal names of states. Okay, there's an arbitral award that says, let's say, Democratic Republic. The respondent is the Democratic Republic of ABC country. And then the arbitrator has issued the award, and the award is ready to be enforced in the enforcement jurisdiction. The courts in the enforcement jurisdiction saw to it that it's Democratic Republic of ABC country. And then they said, we are not a democratic republic. We are a socialist republic of ABC country. So you are already referring to the wrong country. That could be a tricky issue, and then that state or the court will refuse to enforce an award that's naming the wrong party. So be very careful. Number 2, in the body of the award, usually in the second page already, we name the parties in their complete full name, whether it's a company name or an individual's name. All the aliases will be included, and all the addresses of the address. If the parties have, let's say, a name in Chinese and a name in English, then both should be put in there. For individual names, usually the passport numbers would also be included to really pinpoint the correct parties in the contract and in the arbitration agreement. Number 3, the names and addresses of the parties' representatives. There are cases when the party representative, the lawyers, the attorneys, would be different from the initial stages. And at the hearing, suddenly there would be changes. There would be changes sometimes twice, thrice. There are also instances where law firms from various jurisdictions are collaborating counsel. all the names of the law firms involved and the lawyer's assistants should be put in there, plus their contact details, the address, three law firms from various jurisdictions, all the addresses should be there, all their telephone numbers should be there, all their email addresses should be there. Number four, date and heading of the contract, the parties to the underlying contract, and the precise, exact terms of the arbitration agreement. So, is example, the heading of the contract, shareholder purchase agreement, or letter of credit of the contract. Put in there that it's the letter of credit that's disputed, or the shareholder purchase agreement that's disputed, or the joint venture agreement that's disputed. And of course, the date when the contract was entered into. Because why is that important? What if the parties quarreled or disputed on a breach that happened before the date of the contract? That would be questioned, right? That the breach does not arise from this contract because it happened before this contract was entered into. So it's very important to put in the date of the contract. I could not emphasize more that the precise terms of the arbitration agreement can be copied and pasted into the award. Do not summarize the arbitration agreement. It's very important that the precise, the exact term will be put into the award because this is the basis of the arbitrator's jurisdiction. So it's important you put in the exact term. Number five, the place or seat of arbitration. Under the UNCITRAL model law, we refer to it as the place of arbitration. But in best practices, it's usually the legal term is usually called the seat of arbitration. Why is that important? Putting in the seat of arbitration, the parties would know, the arbitrators would know who has the legal jurisdiction over that arbitration. It's usually the courts of that seat of arbitration has supervisory jurisdiction over the arbitral proceedings. So for example, the seat of arbitration is Bangladesh, and then we had the arbitration in Bangladesh. The courts in Bangladesh would then have supervisory jurisdiction over the arbitration proceedings. Number six must also set out that there are the applicable law, the governing law, the rules, the procedural rules. As most of you might know, who are esteemed arbitration practitioners in your jurisdictions, there are various laws, there are various rules and procedural rules that would be made applicable to an arbitral proceeding. One is the governing law of the contract. Okay? The governing law of the contract may not be the law of the seat. For example, I'll give you an idea. Let's say a contract, the underlying contract is governed by the law of, let's say, for example, India. But the seat of arbitration is in Singapore. So you now have two laws to contend with, to deal with. The governing law of India, the law of the seat of arbitration, Singapore. And what if the arbitration was also administered by the Singapore International Arbitration Center, or the SIAC? And the SIAC rules would apply to the procedure. So all these would have to be put into the award. Number seven, language of the arbitration. It's important to set out there in the award that the arbitration would be governed with the language of the arbitration would be, let's say, English. If, however, there are two arbitration languages, for example, language and Chinese, for example, it's important to also say that in case of inconsistencies, the which language would override or would be made applicable, whether it would be English or Chinese. And then, could I go to the next? Yeah, sorry. And then number eight, names and relevant details of the arbitrators. Sometimes in the course of the arbitral proceedings, there will be changes in the arbitrators. One arbitrator will resign, or one arbitrator has, let's say, retired. So there will be changes. That should be put as well into the arbitral award. And the manner with which the tribunal was constituted. Usually, the claimant would nominate one arbitrator. The respondent would appoint one arbitrator, and then both party nominated arbitrators would appoint or nominate the chairman or the president of the arbitral tribunal. That should also be set out if that was the manner by which they were constituted. Secretary of the tribunal would also be put in there. 10, chronology of events leading to the dispute. It's a background of the dispute from the day the contract was entered, and then the performance or non-performance of the obligations. Then there's breach, and then there's now dispute. And then we go to 11, which is the procedural history. This usually starts at the commencement of the arbitration, which is the filing of the notice of arbitration or request for arbitration in the arbitral institution, and ends with the declaration of the closure, declaration of closing of proceedings. The declaration of closure is not in accordance with the UNCITRAL model law or other laws, but it's usually prescribed by the rules of the arbitral institutions. SIAC has that, ICC has that. Why is that important? It's important to put in that the tribunal declared the proceedings closed. That would indicate to the parties that after this date, no more pleading submissions and other issues could be raised already by the parties. Okay? And then number 12, time limits for rendering the award. This is not a common requirement, but some arbitral institutions require this. Usually they have a time limit for the arbitrators to issue an award. And then there would be some extensions, sometimes more than 10 extensions perhaps. That is a monitoring device for the arbitrators so that the parties would see that whether, the arbitrators have been delaying in issuing the award. Next slide, please. Then we go to, this is now the form. The dispute resolution steps under the form of the award. First is the identification of issues. This is not mandatory. This is not in accordance with the law, but this is best practices. This is not even mandatory in arbitral institution rules. If you look at the major arbitral institution rules, we don't have identification of issues as a mandatory step. But according to my experience, according to the experience of a lot of my mentors and a lot of my senior arbitrators, this helps the arbitrators narrow down the issues and then think on just those issues and do their findings, make their findings according to the issues. Usually this is an agreed statement of issues by the parties. If not so agreed, then the tribunal will then put in an agreed statement of all the statement of facts statement of issues based on what the claimant and the respondent has given. And I think in my personal view, this also helps the parties narrow down, their preparation for the witness statements, the expert reports, and up to the hearing. Because this usually happens after the exchange of pleadings, but before the exchange of witness statements. Number 2, we have to put in summaries of claims and defenses into the arbitral award. I will not recommend putting in or copying and pasting all in verbatim, all the claims and all the defenses and counterclaims from both parties. Just summarize. Or else you will have like hundreds and hundreds of pages of arbitral award, which the arbitral institutions might not appreciate. It's just too long. Number 3, request for relief. It's very important to put this one in verbatim. All the requests for relief from the claimant and all the requests for relief from the respondent. And number 4, tribunal's finding and reasoning. This is now where the arbitrator, us, the arbitrators, would put in, okay, one of the issues under the identification of issues, whether or not the claimant or the respondent is liable. Then in the findings, we will say, yes, we find that the respondent is liable to pay, for example, $1 million. And then what is the reasoning behind that? We'll go through the reasoning later on. Number 5, put in as arbitrator, we put in as well as our decision on interest and taxes. Only if the claimant or the respondent are claiming for interest. If they are not claiming for interest, then we have no jurisdiction to decide on interest. Okay? But it's very common that usually all parties claim for interest. And of course, taxes as well. Again, only if the parties are claiming for taxes. Number 6, costs. This is divided into two: arbitration costs and legal costs. The arbitration costs usually cover the arbitrator's fees, the administrative fees from the arbitral institution, and perhaps expenses as well, travel expenses for the arbitrators. Legal costs covers the lawyer's fees, and other expenses that the lawyers has expended for or has spent for the arbitration, including, travel costs for witnesses, travel costs for lawyers, travel costs for experts, the expert fees, and so on and so forth. Number 7, we now summarize all our findings and without the reasoning, all our findings into a dispositive portion, usually at the end part of the arbitral award. For example, dispositive, subparagraph 1. The respondent is held liable to pay $1 million to the claimant on or before, let's say, 20th August 2020. Simple as that, with no more reasoning. Then subparagraph 2. Interest on the $1 million is held at, let's say, 6%, simple interest or compound interest, whatever was claimed. And then interest will be paid up to this date. Simple as that. No more reasoning, because you have your reasoning already prior to that. And so on and so forth. If all the respondents' counterclaims have been dismissed, or if all of the claimants' claims have been dismissed, no one is held liable for anything, then put it there in your dispositive portion as well. The claimants' claims are all dismissed, or the respondents' counterclaims are all dismissed. Okay? Simple as that. Because again, you have your reasoning already at the previous part in the arbitral award. Could you go back to the slide? Okay. And then end page. This is now your end page, which contains the signature of the sole arbitrator, if you have a sole arbitrator, or the signature of the 3 arbitrators, if you have a 3-member tribunal. And out of the abundance of caution, we also put there at the end page the place or seat of arbitration and the date of the issuance of the award. I wish to emphasize, make sure that the date at the cover page and the date at the end page of your arbitral award are the same. Okay? It should not be inconsistent. They should be the same. So be careful with that. And then to be attached to the arbitral award, if you have dissenting or separate opinions, dissenting opinion, if one arbitrator does not agree with the decision of the other 2 arbitrators, then he or she could issue a dissenting opinion. If 1 or 2 arbitrators agree with the findings but disagree with the opinion, with the reasoning, then that arbitrator could issue a separate opinion. That is also acceptable. Next slide, please. So that's the form. We now go to the substance or to the reasoning. Next slide, please.
Ma'am, before going to the next slide, can I ask a question?
Sure.
Is there any fundamental difference between various arbitration centers when the award is drafted in the format of the arbitration award? Is there any fundamental difference, or they're quite same, or what's the general figure of an award draft?
What I have set out is like best practices amongst the arbitral institutions. Some arbitral institutions might not require, but out of abundance of caution for the arbitrator, just put it there. Nothing, there's no harm in putting it there. It's this. What I've set out is the best practices amongst the major arbitral institutions. there's just we will go to gatekeepers later as to like fundamental difference in how the arbitral institutions operate in terms of checking an arbitral award. So we will go to substance of the award. Let's go to reasoning. Next slide, please. Did I answer your question, Mahira? Thank you. Okay. For the reasoning, I would highlight 3 points. Okay. First is, if let's say the arbitrator says that, okay, based on this issue, the respondent is liable. That's the finding already. The respondent is liable for 1 million US dollars. Then set out your reasons why you said so. How do we set out our reasons? Number one, we refer to the applicable law, to the governing law. If the governing law is Singapore or Bangladesh or India, then set out there that the law in Singapore sets out this, and according to the law, the respondent is liable in this case. And then set out why, based on the facts of the case and based on the elements of the applicable law. If your basis for your decision is a rule, an arbitral institution rule, set it out as well. You know, if let's say one of the issue is one of the parties send out like a letter setting out new submissions after the arbitrators have already declared the proceedings closed. That should not be accepted anymore. So the arbitrators did not accept, let's say, and then they will issue a reasoning. They will also set out a reasoning. We did not accept these new submissions because the proceedings had already been closed. And especially if, you know, the arbitrators see that the new submissions wouldn't impact at all, wouldn't affect at all their decisions on the other issues, then sometimes they would have put in, okay, we will not accept the new submissions anymore. And at the same time, law of the seat of arbitration as well. If, you know, the issue is governed by the law of the seat, then set out there the law of the seat as well, why it's applicable or not applicable into the facts of the case. And then reference to documentary and testimonial evidence submitted by the parties. Documentary evidence, I would say the documents submitted already in the course of the arbitral proceedings. Usually, when a party puts out an argument or a submission, then you have documents to support the claim or the counterclaim. For example, if you have like bad weather conditions in a shipping dispute, that's why the delivery of some commodities or delivery of products or goods had been delayed because of bad weather conditions along the way. The delay would be counted based on that bad weather conditions. What documents or relevant documents you could attach to your pleadings in order to support your claim? You could attach, you know, bad weather report from the port authority and all these things. So that's just one example. Let's go back to the other slide. Okay, reference testimonial evidence. If there are hearings, because there are also cases where there are no hearings. If both parties agree just to have a documents-only arbitration, then the arbitrator will only decide based on the documents already submitted by the parties. But if there will be hearings, then there will be witnesses. There will be experts. If your findings as arbitrator is based on what the witness has said at the hearing or what the experts had said at the hearing, then refer to that in your arbitral award as well. And lastly, reference to the applicable case authorities. Claimant and respondent would usually, almost always, have case authorities to support their claim or counterclaim. So whichever is most persuasive or most applicable to the facts of the case, refer to that case authority. That would bolster up or that would be part of your reasoning as well. Next slide, please. Thank you. So this is a fundamental difference that Mahira referred to a while ago in her question. Great question, by the way. Gatekeepers, some major arbitral institutions do award scrutiny. And personally, I like that value-added service because sometimes if there are small details that might have an impact on the dispositive part, or on the major awards, or award, or claim that you have granted, or counterclaim that you have granted. So the counsel at the arbitral institutions, the associate counsel, the counsel would look at the award. They will not change the substance of the award. Okay, they respect how arbitrators have decided based on the on the substance of the award, but they will look at whether there are potential ramifications and some mistakes that might lead to this award getting unenforceable or being set aside. Okay. Number one, a common comment would be the lack of formal or substantive requirements. Earlier on, I gave you an example of naming the wrong parties. Or at the dispositive portion, when the finding should be the respondent is made liable to the claimant, what the dispositive portion had said was that the claimant should be liable to the respondent. That's altogether a wrong dispositive, right? So usually, sometimes the arbitral institutions would be able to catch those and highlight to the arbitrator that this is wrong, this is blatantly wrong. And then the arbitral institutions could also highlight to the arbitrators if there had been wrong computation of damages or interest, or there had been, let's say, in the body of the award, the tribunal said that the liability of the claim amounts to USD $1 million. At the dispositive portion, the claim became Singapore dollars 1 million. So it's a large difference between a USD and Singapore dollars. So usually these happens at the award scrutiny. So this is a great value added service from the major arbitral institutions that many arbitrators appreciate. So this is one fundamental difference between some arbitral institutions and other arbitral institutions. Next slide, please. And then we now go to what to avoid. I've already given you examples early on what to avoid. I've intentionally set out my presentation. I hope it was short but crisp enough, because I want us to have more time for questions. What to avoid? In the first slide, we already set out the New York Convention, Article 5, and the UNCITRAL Model Law, Article 34. Always have a clear mastery of these grounds so that you will be able to avoid setting out what could potentially fall under these grounds, so that, again, your award will not be held unenforceable and will not be set aside. So again, check the New York Convention and the UNCITRAL Model Law, or the applicable law of the seat, for what could be set aside or what could be an unenforceable arbitral award. Let me give you examples. There are two cases that were issued by the Supreme Court of the Court of Appeals in Singapore late last year. One award was set aside. The other one was two awards were set aside based on, as you might see in this in paragraph 1, the arbitration proceeding proceeded under the wrong seat of arbitration. This is a valid ground, because if the arbitration proceeding proceeded under the wrong seat of arbitration, then it falls under the New York Convention or the model law grounds of setting aside, where the arbitration proceeded under a procedure which was not agreed by the parties. Okay, it's a very technical ground. It's a very technical issue which was thoroughly and comprehensively discussed by the Supreme Court of Singapore, the Court of Appeal, in the cases that I mentioned. If you want it for your leisurely reading. The case reference is there under subparagraph 1. Number 2, making decisions on issues not pleaded by the parties or outside the scope of submission. Earlier, I mentioned, if the claimant or the respondent did not request for interest claims or taxes claims, then the arbitrator should not do so. Okay. If the arbitration agreement says costs of the proceedings or cost of arbitration should be paid for by each party, to each his own, okay, then the arbitral award, the arbitrators should not put, that cost should be paid fully by the losing party. You get what I mean? It's already beyond or outside the scope of what was submitted by the parties for resolution and determination by the arbitrator. So again, the arbitrator should not go beyond what was submitted by the parties for resolution by the arbitrator. This was also my example earlier on, setting out the incorrect names of the parties. Okay, the one that I mentioned to you, setting out like a democratic republic of ABC country, and then it turns out that it's a socialist republic of ABC country. That's the full name of the country. Then the country of enforcement would think, this is not us. This is not the state that you're referring to. It's an incorrect name. So they have the right to refuse enforcement. And lastly, as it was also decided upon in one of the cases issued by the Singapore Court of Appeal last year, incapacity of any of the parties. Just to give you a brief background, there were about 20 respondents in this case, and about 5 or 10 were minors in this case. But let me put out a caveat. The minority of these respondents were never put into issue in the arbitration proceedings. So in fairness to the arbitrators, they didn't know that there were minors involved. Okay, so when the case reached to the courts for resisting enforcement or for setting aside, the counsel for the minors already set out that there are minors involved, and I think it's quite a cross-border international practice that minors could not properly enter into a contract and therefore could not be held properly liable for claims under a contract. So I guess these are just 4 of the major points that I wish to highlight that you should avoid whenever you're writing an arbitral award. Let's open the webinar for more discussion and for more questions if you have questions. Mahira?
I had a question that right now you mentioned about any, for example, any technical mistake or clerical mistake. For example, as you said, the name of the country was not the same country which actually was about to enforce the award. If anything like this happens, that was just any typing error or any kind of clerical mistake, can it be corrected after the award was once given for the enforcement letter?
Okay, if we take a look at the UNCITRAL model law or the International Arbitration Act, for example, in Singapore, or the arbitration laws, which is jurisdiction specific, there could be an arbitration act as well for Bangladesh. Look at the provision that allows when an application for interpretation or correction could be filed. So let's say, under the UNCITRAL model law, I think it's 3 months after the issuance of the award. Today is 18th of August, right? So if I issue an award right now to the parties, that should be the first thing that any of the parties would look at. If the parties have been correctly named, any correction that's needed, any mistake in the computation or in the dates and all that. And then you have 3 months, I think 1 month to apply for interpretation, or the correction will be limited only to correction for calculations or clerical errors. That should have been the perfect time to ask for correction and not wait for the award to be enforced in an enforcing jurisdiction and reach the courts already. It will be a sensitive issue, you see, that they're being named under, if it's, especially if it's a state, that they're being named the incorrect name.
And I had another question that is there any limitation of time between the award when it's once signed or and then the enforcement? What is the time gap highest can be accepted here, or is there any kind of time limitation from the award till the enforcement when it goes to the
Mm,
court?
mm.
And can it be an issue that the award can be declared as unenforceable by the court for this time limitation or time bar?
That could be a potential ground for refusing enforcement if it's already time barred. But as far as I know, I wouldn't attempt to set out all the time limitations because I do not memorize. I haven't memorized that, and I will not attempt to do so because the time limitation for enforcing an award depends upon the enforcement jurisdiction. So let's say we did an arbitration in Singapore, but let's say you are the winning party. You're counsel for the winning party. You now have the award, but you will want to enforce this in, let's say, in Bangladesh. Then you take a look at the enforcement of arbitral awards in Bangladesh. If it says 3 months, then you have to apply for enforcement within 3 months. If it says 1 year, then apply within 1 year. It's jurisdiction specific.
And in that case, when an award is written by an arbitrator, do they frame any kind of particular date that this award needs to be enforced within 3 months or within 6 months, or give any time limit while they draft the award? Do they does it or does they do it, or it just depends on the court where the award is to be enforced?
Do I get your question right? If the arbitrators would set out in the award when the award should be enforced? Is that your question?
Yes, whether
Okay.
the arbitrator can set a date in the award while drafting that this needs to be enforced within 5 months or 6 months or within this particular date, or it's totally about it depend on the court or the national jurisdiction where it is to be enforced.
Great question. Um, if it was, I don't think the arbitrators would have jurisdiction to do that because, again, it's a jurisdiction specific law. It's usually the law of the enforcing jurisdiction that would set out the time limit for enforcement of an arbitral award. If we do that as arbitrators, we're going out of the submissions, the scope of the submissions already, and it's outside our jurisdiction. It can be questioned under setting aside or under resisting enforcement. And that might be stricken off the arbitral award. Potentially, that might be stricken off.
I think we have questions from the audiences. Should I refer to you?
Yes, yes, sure. I think I can see it.
Ma'am,
You want me to read it? Yeah. How will
ma'am,
you
I can read it out for you.
Okay, sure. Thank you.
Zahirahan Khan has asked, how will you manage to draft an award if the parties are not consenting to sit with one language? Shall we draft three language including English, or it only we have to the parties' language?
Great question. This is a common issue in arbitral proceedings. First and foremost, look at the arbitration agreement. Usually, the language of arbitration would be set out there. But there are instances that could be forgotten, that might not have been agreed during bargaining or negotiation stage. So there's no proper agreement as to the language of arbitration. Then early on, from the start of the arbitration, that should be put into issue already before the arbitrators. One, either the claimant or the respondent would say already, we have not agreed on the language of arbitration. We submit that, let's say, English should be the language of arbitration. If the other party does not agree, then the arbitrators would have to decide early on and not wait for the award stage. That should have been clear already from the start.
Ma'am, if we uh, ask you to tell from your experience that what are the main reasons in our Asian countries, our national jurisdictions, that actually becomes a pitfall that they really feel reluctant or sometimes or most often time don't want to enforce any foreign award.
Could you clarify that first part? What are the pitfalls from the investor side or from the foreign investor side?
No, ma'am. I asked it from the court side. When an arbitration award is going to be enforced by any court or any jurisdiction in Asia, what are the reasons or
Mm.
are general pitfalls that actually bars an arbitration award to be enforced from the by the courts or national jurisdiction?
Okay, I get it now. Thank you for the clarification. Four of those that had been decided was part of my presentation, the last slide. Um, it's also important to look at case authorities from various jurisdictions, especially if that jurisdiction is where you're going to enforce your arbitral award. Um, um, I will not name countries, I will not name jurisdictions, but there had been cases or awards that had been refused enforcement or set aside based on public policy exceptions. We discussed, we've mentioned public policy, and public policy ground is just so vast, and it could go on varying degrees wherever you go. Public policy exemption in one country might not be a public policy exemption in another. So that is again a tricky issue. In Asia, there had been awards that have been refused enforcement or set aside based on the public policy exception because the award said that costs, all the costs of the arbitration should be borne by the losing party when the parties did not agree on anything to that effect. It was set aside based on just the costs, the cost award, because it was not agreed by the parties. I wish to highlight that as per best practices in international arbitration, usually we follow costs follow the event, and then the losing party would have to shoulder all the costs in the arbitration, including the costs from the winning party, unless of course both parties agree at the arbitration agreement that to each his own. So the claimant will shoulder its own cost, the respondent will shoulder its own costs. I hope I answered your question.
Yes, ma'am.
That's just
Well,
one example.
we have received another question. You can see on the screen. What is your advice to young arbitrators to avoid set aside award later on?
Great question. I assume if we're a young arbitrator, then we still have like a few number of cases before us where we are appointed as arbitrator. I would advise to read as much as you can. Get a mentor. Get a mentor, an arbitrator who has been in the field for so many years and has experienced a lot of issues already in the arbitral proceedings, and learn as much as you can from these mentors. There's a lot of issues arising from arbitral proceedings that could not be taught inside the classroom, and yeah, that's very important.
I had another question. It's actually the substantial question of what I asked for. That how much discretion an arbitrator enjoys while drafting an award. We have you have pointed out the basic standards or general or best practices, but still, if we talk and also that any arbitrator cannot award anything which the parties didn't claim for. But still, if we go to talk about the discretion of the arbitrator while writing an award, how much can they exercise in this particular?
Um, Discretion would, as you mentioned, would fall under the scope of what was submitted. So you have discretion to move around within that scope. But outside that, you will run into the danger of having your arbitral award set aside or resisted enforcement. Uh, that is the extent of discretion for an arbitrator.
Thank you, ma'am. I think I don't have any question, but
Ah,
we can wait for a few moments for if any question
yes,
is
please.
gathered.
Yeah, please. Happy to
There,
address
yes,
questions and any other questions from our attendees. Do you? Yeah, you could read it for me if you want.
yes, I can read it for you. Online Dispute Resolution ODR Institute have asked, do you think that there always should be a mentor for young arbitrators?
um, I hope so. Not everyone would have the free time to do so because these are usually full time and very busy arbitrators and doing their livelihood. But if you'll have a chance to attend, these things, webinars, conferences, events where you'll have a chance, hopefully, post-COVID times, we'll be meeting again in person, and there will be more time to engage with senior practitioners, or practitioners, even, the younger practitioners, but with substantial experience. Then, engage with them, ask them all your questions. It would greatly help if you will work with them, do internships with them, and you, because you go inside into the internal workings of the mind of an arbitrator, how they deliberate issues, how they attack these issues, and how they resolve the disputes. There's so many issues in an arbitral proceedings that I haven't learned while in law school. So, and I've just only learned while doing the work of being an arbitrator or being a tribunal secretary.
And from your point, is there any opportunity or scope for the young students or the young learners or arbitrators who want to pursue their career as a future counsel or arbitrators that they assist the arbitration with their fellow lawyers or arbitrators or be inside the court, because as you said that the knowledge we get from the book and also inside the courtroom, that's a totally different scenery. So is there any possibility or any scope for the young learners or arbitrators who want to assist them inside the courtroom of the arbitration or
Hmm.
by
Mm-mm.
any ways?
Yeah, that's a tricky part. That's a tricky part because uh, most number of arbitration cases are usually just in a small number of places. Uh, for example, even if Bangladesh has a growing number of arbitration cases, including investor state arbitrations, but usually the arbitrators would come from other places. Same thing from same thing from the Philippines as well. The arbitrators would come from various places, not from the Philippines. Um, but so slowly, we just have to keep on promoting these jurisdictions that there's an increasing number of competent arbitrators from these areas or from these countries, so that the young learners based on these countries would be also exposed to these cases and to the workings of these arbitrators. We should hope so in the future, as um, um, more grounds for diversity in arbitrator appointments would be enforced. Let's say, but let's see in the future. I hope in the not too distant future. Do you have any advice? I sorry.
Ma'am, see, there is a question from Center for International Alternative Dispute Resolution, CIDR, that do you have any advice for new arbitral institution like us?
Everyone starts from the very beginning, so to speak. And that could mean 0 cases. That could mean 10 cases in the first year, or in the first 5 years. That's how the major arbitral institutions started. But even then, early on, they focused on business development, promotion, marketing, going out there saying, that, we do this and that, we are capable of this and that. And then perhaps highlight in the arena filled with a lot of arbitral institutions now, highlight what your unique selling proposition is, or the USP. What could a new arbitral institution offer into a vast pool of arbitral institutions that's not yet offered by the other arbitral institutions? Then highlight that in your business development activities.
Ma'am, I think we have not received any other questions, but still we can wait for a few seconds. If there is any question, we will get it in the screen, and if there
Sure.
is not, then I think we should be able to end our session.
Sure. And thank you again for all your patience for, the technical difficulty that we encountered early on.
Ma'am, actually, technical difficulties are unavoidable at some points, and really, no party has any kind of influence over that. So it's just, I think it's natural and it's totally all right.
Yeah, thank you. So I also prepared a PDF version of my Prezi presentation. Any one of the attendees who want a copy, yeah, you could give it to them as well.
Yes, ma'am. We have all your PDF presentation, and we will serve it to all the young learners of our group. And
Yeah.
I think we don't have any more questions, and we can end our session for today
Thank
now.
you very
And
much. And thank you,
thank you.
Mahira.
Thank you very much for your valuable insights. And I think it was a very thorough discussion from your part, and it was very much precise and also understandable. And I think it will help all the young learners and also the practitioners in their pursuing their career in this stuff. And
Good
we
luck.
are very much lucky having you among us, and
Thank
we
you. Thank you
wish
for the
you good luck
invitation.
and
Thank you
good
for the
health.
kind invitation from CIADR. Thank you, Mahira. Thank you, Mr. Udin and Mr. Al Masood. And here's hoping that post-COVID times, we would get to meet again in person in arbitration events and conferences in the future. Stay safe and take care, everyone.
Yes, ma'am. Thank you so much. Goodbye.
Bye.